Good afternoon, everyone. I'm Attorney Vixon A. Mabanglo from the Legal Edge Bar Review Center, and we welcome you all to our free lecture on the Anti-Money Laundering Council, powers and functions under existing laws and changes under the proposed Anti-Terrorism Act of 2020. Our lecturer for today is Attorney Jose Angelo A. David. Associate Solicitor Jose Angelo Anjo A. David represents the Anti-Money Laundering Council among other government agencies in cases before trial in appellate courts. He also acts as counsel on behalf of the Republic in constitutional litigation and domestic and international arbitration proceedings. Prior to joining the civil service, he was an associate at Angara, Abelio, Concepcion Regala, and Cruz law offices. Attorney Anjo obtained his bachelor's degree in political science cum laude from the University of the Philippines in 2010, and his bachelor's degree in law from San Beda University as the Class Valedictorian in 2014. He ranked sixth in the bar examinations administered in the same year. He also holds a diploma in Spanish law from the Universidad Internacional de Andalusia. In May this year, Attorney Anjo obtained his Master of Laws degree from the Harvard Law School, Harvard University. He is a law professor at San Beda University and Far Eastern University, and he is also a bar lecturer at the Legal Edge Bar Review Center. Everyone, let us welcome Attorney Jose Angelo A. David.
Magandang hapon po sa kanilang lahat. This is Angelo David speaking. And thank you so much for attending this lecture. Let me open my video. Okay, is it working, Vixon?
Yes, Attorney Anjo. It's
okay.
working.
Okay, I'm just gonna share screen. Kita?
Yes, kita, Attorney Anjo.
Okay, sige. Alright. So again, magandang hapon po sa kanilang lahat. I'm still currently in the United States, and as Vixon said a while ago, of course, thank you so much, Vixon, for that very generous introduction. As Vixon said, I'm currently still in the United States, and today we're going to discuss the Anti-Money Laundering Council, specifically talk about the powers and functions of the institution under existing laws and the proposed changes under the proposed Anti-Terrorism Act of 2020 or the Anti-Terror Bill. So first of all, I would like to ask a question. Why do we have to study the AMLA? What's the interest in the Anti-Money Laundering Act? So I have a few reasons here. The first one is that there have been several amendments since the law's enactment in 2001. So it's important for us to be able to go through all of these amendments and make sure that we are updated, that we have kept ourselves abreast of the legal developments when it comes to the AMLA. And there have been many. So there have been laws that directly amend the AMLA, and there are some laws as well that indirectly amend it. In other words, there are some laws which are not organic to the AMLA, which also provide some amendments to the law. So we have to consolidate all of these laws and make sure that all of them that we are at par with all of these legal enactments. And then next, of course, considering that we're here in Legal Edge Bar Review Center, we have to point out that the AMLA, or the Anti-Money Laundering Act, is a bar examinable material. It's specifically included in commercial law, part of the syllabus of commercial law. It has been for the last few years, I think. And so we're going to discuss some of the provisions, some of the topics covered by the bar exam syllabus for this year, which I believe has been moved to next year. And of course, the AMLA, or the practice of anti-money laundering, is in and of itself a practice area. So perhaps it's little known, but there have been many cases also filed in court involving the Anti-Money Laundering Act, be it for the prosecution of criminal cases or for remedial proceedings filed before the trial court or before the regional trial court or before the Court of Appeals. So I think it's important for us to be able to know how the Anti-Money Laundering Act is implemented in court or in court practice. And like I said a while ago, there have been, or there are proposed changes under the anti-terrorism bill, and it's interesting to go through them and see how this anti-terror bill, the proposed law, which is of course awaiting the president's signature, how it affects the Anti-Money Laundering Council, its powers and functions, and the entire scheme of anti-money laundering in the Philippines. So just a brief overview. First, we'll have to go through the legislative history of anti-money laundering law here in the Philippines. We're going to look at some historical contexts, some international obligations that affect the enactment of laws, anti-money laundering laws here in the Philippines. And then we're going to discuss the crime of money laundering. I'm going to give you an idea of what money laundering is, and then the functions and powers of the Anti-Money Laundering Council, and of course the remedial proceedings, such as the issuance of a banking freeze order, and of course an order of civil forfeiture, which is the outcome of a civil forfeiture case, or one of the primary goals of anti-money laundering laws, which is to get assets, the proceeds of money laundering. So this is how we're going to discuss our how we're going to proceed with our discussion today. And I think that this overview, this agenda that we have now, it's a bit packed, but I think it addresses the goals or the objectives of why we want to study AMLA today. So let's go to the legislative history. Let's begin with the discussion of some international obligations. So when we talk about international obligations in the Philippines, a way to be bound, one way to be bound by these international obligations, and I suppose even for other countries, would be the doctrine of transformation. So once a state, like the Philippines, for example, decides to enter into an international treaty or agreement, that treaty or international agreement becomes binding upon the Philippines. So there are some international obligations, or some obligations that are deemed legally binding upon the Philippines by virtue of this doctrine. So of course, once the president ratifies a particular treaty and it has been concurred in by the Senate, pursuant to Article 620, Section 23 of the 1987 Constitution, then that gives rise to certain international obligations. And in relation to money laundering, there are three treaties or conventions that I want to emphasize, and one, a political declaration, for which anti-money laundering obligations have arisen. The first one is the 1988 Vienna Convention against illicit traffic in narcotics. The second is the International Convention for the Suppression of the Financing of Terrorism. And the third one is the United Nations Convention against Transnational Organized Crime. And the fourth one is a General Assembly resolution, a UN political declaration and action plan against money laundering. So let's just go through them one by one. So this is a part of the text of the 1988 Convention on Narcotics. And as we can see from the preamble, it begins with an introduction of the bane or the problems that arise from illegal drug trafficking. So it says here that states that sign this particular agreement are aware that illicit traffic generates large financial profits and wealth, enabling transnational criminal organizations to penetrate, contaminate, and corrupt the structures of government. So it comes from a belief that bad money, dirty money, is bad for the economy. And it affects also the legitimate commercial and financial businesses and society at all its levels. So that's where we're coming from. That's the policy behind the prosecution of and prevention of money laundering. And it says here that states are determined to deprive these persons engaged in illicit traffic of the proceeds of their criminal activities, and thereby eliminate their main incentive for so doing. So again, another premise is that when it comes to the illicit traffic of proceeds, when it comes to illegal drug trafficking, one of the incentives for why parties do so, or for why people engage in such a crime, is because of the proceeds. So if we cut off the incentive, if we cut off the money that goes behind or goes through this illegal practice, then the commission of the crime would be much deterred. So that's another premise upon which anti-money laundering laws are created or enacted. And in Article 5, it states here that each party who is a member of this convention shall adopt such measures as may be necessary to enable the confiscation of proceeds derived from offenses established in the law pertaining to narcotic drugs and psychotropic substances. So the Philippines has ratified and signed this particular convention. The next one, as I said, is a political declaration. It's basically a reiteration of the 1988 convention. So it says here that states shall undertake to make special efforts against the laundering of money linked to drug trafficking. And it also enjoins the states to emphasize the importance of strengthening international, regional, and sub-regional cooperation. Okay, so why is there a need to emphasize the importance of strengthening international, regional, and sub-regional cooperation? Another premise behind anti-money laundering laws, not only in the Philippines, but also in the entire world, is that a weak enforcement system in one country is a way for anti-money for money laundering, for money laundering to flourish. So in other words, criminals would always find a way or find a country where they could make use of or find the loopholes in that particular country and engage in money laundering there. And so there's a need for all countries to coordinate and cooperate. And that's why, based on this political declaration, states have committed to adopt by the year 2003 national money laundering legislation and programs in accordance with the UN Convention on Narcotics in 1988. Now, later I will be discussing that the Philippines enacted its Anti-Money Laundering Act in 2001. So at least 2 years before the 2003 deadline set forth in this General Assembly resolution. Another convention that we need to take note of is the International Convention for the Suppression of the Financing of Terrorism. Now, this convention existed way before the September 2011 attacks. And it says here that each state party shall adopt such measures as may be necessary to establish as criminal offenses under its domestic law the offenses set forth in Article 2. So it pertains to terrorism and financing of terrorism. And to make those offenses punishable by appropriate penalties. And then in Article 8, it enjoins each state party to take appropriate measures in accordance with their domestic legal principles for the identification, detection, and freezing or seizure of any funds. So just like the intent for narcotics, the same principle applies for terrorism and the financing of terrorism. So in order to prevent terrorism and the financing of terrorism, this convention establishes a regime, or at least enjoins states to establish a national legal regime that would identify, detect, and freeze proceeds of terrorism or the financing of terrorism. So it's another tool for money against money laundering. And the next one is the UN Convention Against Transnational Organized Crime. Oh wait, it says here no audio. Vixon, can you hear me?
Meron, attorney.
Okay, may nakuha kong chat, no audio from a panelist. Paano to?
Sige, I'll address it na lang, attorney. Just
sige.
continue your lecture.
Okay. Oh, okay. Wait, Okay, let's go back. Okay, we're done with this. Next is the UN Convention Against Transnational Organized Crime. Again, it pertains to the criminalization of laundering of proceeds of transnational organized crime. So it pertains to, there's a definition for transnational organized crime in this convention. Okay, this person is saying I lost audio. But anyway, sige, Vixen, kindly please just address this.
Yes, Atty. Yes.
Okay, sige. Thank you. Dali. Okay. Same tenor as the other treaties that I mentioned a while ago. The Philippines is also a state party to this particular convention as of 2002. Now let's give some historical context, some factual context behind these conventions, behind these treaties, and of course extending also to anti-money laundering legislation in the Philippines and anti-money laundering treaties. So some of you may have seen it on Netflix or from some documentaries. So back in the 1970s, 1980s, Pablo Escobar from the Medellin cartel in Colombia, and he was that cartel was one of the biggest, if not the biggest, in the Americas, and it even controlled over 80% of cocaine shipped to the United States. So that was how big the problem was, such that 300 billion US dollars of drug trafficking proceeds worldwide were estimated by the United Nations. So the drug trafficking cartel, or the cartel of Pablo Escobar, reached its highest proportions in the 1980s, which was a few years or like a decade before the conventions that we were talking about earlier with regard to narcotics. So you will recall that the Convention on Narcotics was ratified by the Philippines at least in the 1988, 1989. And that's also when that particular treaty was entered into by most other countries. So that was a context, some historical context behind the ratification of those particular treaties or conventions. And again, the Philippines is one of the state parties. And then in July 1989, the Financial Action Task Force, an international body that perhaps you've heard of recently, was established during this G7 summit held in Paris. So there's a photo there. You may see 8 people. The reason why you have 8 is because the European Commission is also part of it. But the members of the G7 then were, well, even now, were Italy, United Kingdom, United States, France, Germany, Canada, and Japan. So these are developed countries which have decided to band together. Russia used to be a part of this organization, but they were booted out in 2014 when they annexed Crimea, Ukraine, and the other parties just said, no, we're not going to let you be part of the G7, of the G8 anymore. So now there are only 7 members again. And here in this particular photo, the European Commission was also part of it. That's why you see 8 of them in that photograph. But this was on July 14, 1989, when the Financial Action Task Force was created. And then just a year later, even less than a year later, the Financial Action Task Force issued 40 recommendations. These 40 recommendations are international standards to be followed not only by the member countries, well, primarily by the member countries, and there are now 39 member countries and jurisdictions, as well as different subgroups. So the Philippines, in fact, is not a member of the Financial Action Task Force per se, but it's a member of the Asia Pacific Group, which in turn is a member of the Financial Action Task Force. So because of that, the Asia Pacific Group applies the standards of the Financial Action Task Force, and the standards that I'm referring to are the 40 recommendations. So these 40 recommendations, they started in April 1990, but they have undergone several changes throughout the years, particularly as I will be discussing later, when the 9/11 terrorist attack happened. So that's when the 40 recommendations started changing. And again, after these recommendations were enacted in 1991, the FATF members started to implement the 40 recommendations. So that's the first time that the members of the FATF decided to implement their 40 recommendations. It was basically a trial run. And every 3 years, the FATF would conduct monitoring and assessments. And later we'll be discussing the history of the mutual evaluation reports involving the Philippines. As of now, there are 39 member countries and jurisdictions and several observer countries. So the Financial Action Task Force, if you've heard in the news, is a body that would inform other countries of the compliance or non-compliance of particular countries with those standards, the 40 recommendations. And a country's inclusion in that list of that public notice saying that you're not compliant results in some countermeasures or could result in some countermeasures from other countries. And as I mentioned, the Philippines is part of the Asia Pacific Group, and the Asia Pacific Group of the FATF is an autonomous regional anti-money laundering body. It was established in 1997. The Philippines is a founding member. In fact, the Philippines was co-chair from 1998 to 2000 through the Department of Foreign Affairs. The APG is an associate member, and as such, through the terms of reference of the Asia Pacific Group, it specifically stated that the APG will adopt the FATF's recommendations and use them as international standards against both money laundering and the financing of terrorism. So let's go to the Philippine setting. Let's focus on the Philippine setting now, given the historical context and given the international obligations that we talked about. Let's look at the enactment of Republic Act number 9160. The Philippines was included in the NCCT list, or the non-cooperative countries and territories list, in June 2000. So what is this list? Okay, ano ba yung ibig sabihin ng mapasama sa listahan na to? Dean's list ba to? Well, unfortunately not. It's actually the reverse, or the opposite of it. If you're included in the NCCT list, it means that you are only partially compliant or even non-compliant with the 40 recommendations. Okay, and back in June 2000, the Philippines was included in that list. So remember, in June 2000, there was still no anti-money laundering law in place in the Philippines. And that's one of the reasons why the Philippines was even included in this list. And back then, in June 2000, the Philippines was already a signatory to, or has ratified, the conventions that we discussed a while ago. But even then, the Philippines was not able to enact any measures, any laws that would combat money laundering. So the Philippines was included in this NCCT list. And because of this list, as I said earlier, it entitles the members of the FATF to impose some countermeasures. And these countermeasures include, among others, the imposition of stringent requirements for identifying clients and enhancing advisories regarding banks coming from the Philippines. It also involves a warning to non-financial sector businesses in other countries that conducting transactions with entities from the Philippines might run the risk of money laundering. Because of these warnings, because of these stringent requirements and measures, there's every incentive for other countries or for private entities from other countries to do business with Filipino companies, with Philippine banks, with Philippine non-financial sector businesses. So that's the disincentive, or in other words, like, it's a penalty, in fact, for countries that are non-compliant and those who are included in the non-cooperative countries and territories list. So in June 2000, the Philippines was included in this list, and the FATF said, okay, Philippines, we're giving you until September 30, 2001 to comply with the 40 recommendations. Okay, and guess what? The Philippines enacted the Republic Act number 9160 just a day before the deadline, September 29, 2011. 2001. And what happened between June 2000 and September 30, 2001? We have to remember that the September 11 attack happened then. And although terrorism was already an issue back in 1998 through the convention that I referred to earlier, more light was given or more emphasis was given on preventing terrorism and the financing of terrorism after 9/11. So if you will remember, or for some of you who might not have been aware of this, the 9/11 attacks against the United States are said to have been financed by the extremist group Al Qaeda, a terrorist organization headed by Osama bin Laden. And the reason why Osama bin Laden, at least purportedly, held these attacks against the United States was because of the involvement of the United States in the Gulf War. And about 3,000 people were killed in the United States because of the 9/11 attacks. So there were 4 suicide attacks. One of them failed. It crashed in, I think, in Pennsylvania. And in September 28, 2001, the United Nations adopted Security Council Resolution 1373. The Security Council 1373, Resolution 1373, you may have heard of it as well in the news. It's one of those mentioned in the anti-terror bill, because the UN Security Council 1373 and subsequent resolutions, this entitled the United Nations Security Council to list down several terrorist organizations, or to designate terrorist organizations or certain individuals or organizations as terrorist organizations. So this UN Security Council was, in the first place, a call for many countries to begin the enlisting or designation of certain organizations and individuals as terrorist organizations. And in so doing, it would involve, for example, the freezing of their assets, or authorize the state to inquire into their bank deposits. And then in 2001, October 2001, just a month after the 9/11 attacks, the FATF issued 8 special recommendations, now there are 9, to deal specifically with the issue of terrorist financing. So what's the connection between these 9 special recommendations and the 40 recommendations? So we call them the 40 plus 9 recommendations. And the FATF, together with the APG, of which the Philippines is a part of, they use these standards so that the countries who are members of the FATF, or their specific subgroups like the APG in case of the Philippines, would comply with these particular recommendations. And these recommendations are to be monitored and evaluated by the APG or by the FATF. And that's where, if you read it in the news, that's where the AMLC recently has been saying that one of the reasons why there's a need for the anti-terror bill to be enacted is because of the potential inclusion of the Philippines in the gray list. So let's go back. Let's look at some history again of the Philippines' compliance with the FATF recommendations. So as I said earlier, the AMLA, Republic Act number 9160, was enacted just a day before the September 30 deadline set by the FATF. And then 2 years later, or within 2 years, the FATF conducted another round of evaluations in the Philippines. And 2 years later, the AMLA was first amended through Republic Act number 9194. So why was the AMLA amended just 2 years after it was first enacted in 2001? One reason why was under the AMLA, the original AMLA, RA 9160, the threshold amount to be considered a covered transaction was a hefty sum of exceeding 4 million pesos. So that was how big it was. So in 2001, when the AMLA was first enacted, the law required that for purposes of transactions to be covered, in other words, to be reported by covered institutions like banks to the AMLA, the transaction should exceed 4 million pesos. And because of that, the FATF said, okay, that's too much. That's too big. If you set that amount, that threshold amount of 4 million pesos, it's not going to trigger a lot of transactions. And by then, you wouldn't be able to tell whether a certain transaction was actually already involved in money laundering. So in other words, it was too under-inclusive. That kind of provision was too under-inclusive. It would let go of many transactions. So the FATF said, okay, if you don't change that, then we're going to keep you in the NCCT list take note that the Philippines then was still on the NCCT list. So the Philippines decided to amend the Anti-Money Laundering Act. This was still under the time of President Gloria Macapagal Arroyo, and they reduced the threshold. So from the original 4 million pesos, it's now exceeding 500,000 pesos. And later we're going to discuss the changes to this provision, but general rule, covered transactions involve those transactions which exceed 500,000 pesos. Okay. And then 2 years after the AMLA was amended, RA 9194, on February 2005, the Philippines was finally removed from the NCCT list. But this didn't mean that the Philippines was absolutely free or that it was totally compliant already. As in fact, when the FATF conducted another mutual evaluation in 2009, the FATF found that the Philippines was compliant with only 3 recommendations. For the others, it was only largely compliant, partially compliant, and non-compliant. And you can see the figures, the numbers there. The Philippines was partially compliant with 28, and other figures, as you will note. And this was a cause for concern for the FATF. So the Philippines, again, was informed of these developments. And the Philippines entered the International Cooperation Review Group in October 2010 because of the 2009 Mutual Evaluation Report. And the Philippines' inclusion in the International Cooperation Review Group process, or ICRG process, meant that it was included in the dark gray list. So in other words, it was a notch down from the NCCT list, but still the Philippines was not totally compliant. And the Philippines, of course, was making progress, but not sufficiently enough based on the action plan that was released in the 2009 Mutual Evaluation Report. In 2012, 2 years later, the Philippines was upgraded to the gray list. So again, that's one notch lower than the dark gray list. In other words, the Philippines was getting better and better in terms of its compliance with the anti-money laundering framework in the international level. And in 2013, that was when the Philippines was eventually removed from the gray list, finding that the Philippines had been complying at least enough or sufficiently with the FATF's ongoing global anti-money laundering and counter-financing of terrorism process. And from 2014 to 2017, the Philippines was subject to expedited reporting to the APG, Asia Pacific Group, on the ICRG. And there was a specific concern on the regulation and supervision of the casino sector. Now, what happened between 2014 and 2017? If you will recall, that was when RCBC was involved in a bank heist with Bangladesh and another bank in New York. And it was learned that the money was laundered through the casino sector here in the Philippines. And at that time, from 2014 to 2017, the casino sector was not yet considered as a covered institution. So guess what? Naturally, it also became another problem for the FATF. The FATF said, okay, you have to change your law. You have to include the casino sector in the covered institution. And under the Duterte administration, the casino sector was finally included as a designated, as a covered institution. So it now has, the casino sector now has repertorial obligations under the AMLA. So in October 2019, that's the most recent report. October 2019, last year, the APG released its mutual evaluation report on the Philippines and found that the Philippines was compliant with 8 recommendations, largely compliant with 20, partially compliant with 11, and non-compliant with 1. Okay, so does this mean that the Philippines is again included in the NCCT list because we have 1 non-compliant obligation? The short answer is no. When you go to the FATF website and look at the publications of the FATF, or specifically look at the executive summary of the APG report, it's like 290 plus pages. But if you want a brief reading of this report, you could just look at the executive summary. But it doesn't say there that the Philippines has been included in the high risk or monitored jurisdictions. That's what the call these countries now. So the Philippines is not included in the list of high risk and monitored jurisdictions. However, we have to take note that the Philippines is still partially compliant with 11 and non-compliant with 1. And we're only talking about technical compliance here. When we look at the report, there's another factor called effectiveness of the implementation of anti-money laundering legislations. So the ones I've put in here, these things on the October 2019 MER, I'm only referring to technical compliance. But the Philippines has been found to have low effectiveness rating for some of the recommendations pertaining to effectivity of the enactment or of the enforcement of the law. And this perhaps is the reason why the Anti-Money Laundering Council has been pushing for some changes to the counterterrorism financing framework of the Philippines in relation to money laundering. And one specifically with regard to the non-compliant recommendation that pertains to the non-proliferation of weapons of mass destruction. That's one matter that's specifically addressed as well in the anti-terror bill. Okay, so please take note of these things. So again, if you look at the FATF, it's a public document, it's a public record there. You could just go online and see it. The Philippines is not included in the high risk and monitored jurisdictions, but my perspective on this is that there's every incentive for the Philippines to nonetheless try its best to comply with the standards and be largely compliant at least on all the recommendations. So let's go to the anti-terror bill before we look at the existing framework. What's in the anti-terror bill for the Anti-Money Laundering Council? Okay, so let's look at the remedies of a freeze order and a bank inquiry order. As I will be discussing later, as a general rule, a court order is required in order for the Anti-Money Laundering Council to inquire into bank deposits. Okay, so there should first be a bank inquiry order from court, from the Court of Appeal specifically. With regard to the freezing of assets and monetary instruments, again, as a general rule, there should be a freeze order obtained as well from the Court of Appeals. That's the general rule. The proposed anti-terror bill here now proposes that a freeze order or a bank inquiry order be dispensed with, at least not from the court, but that the Anti-Money Laundering Council, either upon its own initiative or upon the request of the Anti-Terrorism Council, which is primarily composed of cabinet members, authorized, the Anti-Money Laundering Council is authorized under the anti-terror bill to freeze some assets and to inquire into bank deposits. So that's in Section 25 in relation to Section 36 and Section 35 respectively. Now, question, is there anything new about these provisions? Is it not that under existing laws, the Anti-Money Laundering Council already has some powers upon its own initiative, meaning even without the necessity of a court order, to freeze some assets and to monetary instruments specifically, and to inquire into bank deposits? Well, the answer is yes. But if there's one thing that the anti-terror bill makes it different for the Anti-Money Laundering Council, is that it makes reference to a designated individual, groups of persons or organization, or a preliminary order of prescription from the Court of Appeals. So what do we mean by these individuals, groups of persons or organizations designated as terrorists? So earlier I mentioned that there's a UN Security Council Resolution 1373 and subsequent resolutions issued by the UN Security Council, which lists down some groups of persons or organizations identifying them as terrorists. So if a person is included in that list of the UN Security Council resolutions, then what happens is that the Anti-Money Laundering Council, upon its own initiative or at the request of the Anti-Terrorism Council, without need of a court order, the AMLAC can now freeze the assets, the monetary instruments of those designated individuals, groups of persons, organizations, or associations. Okay. This is different because under existing laws, when the AMLAC wishes to freeze or to inquire into bank deposits, the requirement is that there should first be a finding of probable cause. Now, under the proposed anti-terror bill, the UN Security Council resolution stands as that proposition that, okay, the UN Security Council has already determined or designated these individuals, groups of persons, as terrorist organizations. And that stands for the probable cause finding of the Anti-Money Laundering Council. Okay. So again, this anti-terror bill is still pending the signature of the president. But the UN Security Council resolution, it's one of those things that's included in this anti-terror bill, and I suggest that you go and look into it as well if you have the time. But just for purposes of comparison, that's what I wanted to emphasize. So the anti-terror bill, if an individual, a group, or an organization or association has been designated already by the UN Security Council, then that dispenses with the probable cause finding requirement of the Anti-Money Laundering Council. So let's go to the legal framework. Okay, like I mentioned a while ago, the AMLA was enacted on September 29, 2001, just a day before the September 30 deadline set by the FATF. It was amended in 2003, again, for the purpose, among others, of lowering the threshold of covered transactions. And then after that, the Philippines in 2005 was taken off the NCCT list. 2009 came, the Philippines underwent mutual evaluation, and there were many partially compliant, non-compliant provisions. So the AMLA was strengthened, specifically with regard to the freeze order powers. And in the same year, the 2012 losses were all under President Noynoy Aquino. In 2012 as well, after the AMLA law was amended, the Terrorism Financing Prevention and Suppression Act was enacted, which penalizes acts of terrorism in addition to or in relation to the Human Security Act, and specifically prevents and suppresses terrorism financing. So this law, the Terrorism Financing Prevention and Suppression Act, it's one of those laws, together with the Republic Act number 10365, that served as the reason why the Philippines in 2013 was eventually removed from the gray list. Because now we had the law that specifically addressed terrorism financing, prevention, and suppression. So, okay, let's go back to the historical context, to the factual context that we were talking about a while ago. The FATF initially was created for purposes of preventing and prosecuting money laundering with drug trafficking as the predicate offense or the predicate crime. And then eventually, several predicate offenses were added into it. 2001 came, 9/11 terror attacks against the United States. The entire world, through the UN Security Council, decided it's time that we strengthen our efforts against terrorism financing. Mutual evaluation reports on the Philippines found that the Philippines didn't have enough laws to prevent and suppress terrorism financing until finally the law was enacted in 2012. And the AMLA law the AMLAC, in fact, was further strengthened in 2012, specifically with regard to freeze orders. So before, only the Court of Appeals, okay, only the Court of Appeals can issue a freeze order or bank inquiry order. That was the rule before, 10365, Republic Act number 10365. But then changes were made. I will be discussing more specifics of this later, but just for an overview, the law was amended, RA 9160 was amended further until 10927, designating casinos as covered persons and enlarging the powers of the AMLA with regard to the the freezing of assets and the power to inquire into bank deposits, even without a court order. So ito po yung legal framework ngayon na titignan natin. When we're talking about AMLA, these are the laws that you have to look at from 9160 to 10927. All right? It's not enough that you just look at one or two. You have to look at all of them. Because if you look at 10365 specifically, if there's anything that Congress should do, it's to just put the entire law again in one code, in one legislation. Kasi po ngayon, ang ginawa nila, patsi-patsi. So 9160 nag-start, there's one whole law. And then specific provisions were just amended through the subsequent legislations. So if there's any change that Congress should be doing, at least, okay, at minimum would be to like consolidate all of these laws to make it clearer, involving finally 10927, Republic Act number 10927, including casinos as covered persons under the AMLA. So these are all, I'm talking about legislations here. But of course, as we know in the Philippines, when we talk about the legal framework of a law, it's important as well that we look at the issuances of the executive department and the judicial department, and there have been many. So the executive issuances, you have to look at the revised implementing rules and regulations issued by the AMLAC. The most recent one was in 2018, before that 2016, and before that I think it was in 2009, if I'm not mistaken, but the most recent one is 2018. This reflects now the implementing rules and aside from the revised implementing rules and regulations issued in 2018, which took effect in November of that year, the AMLAC also issued separate rules pertaining to casinos. So when we talk about executive issuances of the AMLAC, and this is specifically relevant to covered institutions, dalawa po ang tignan natin. Revised implementing rules and regulations, which were promulgated in 2018 and took effect also that same year, and the casino implementing rules and regulations pertaining to Republic Act number 10927. Dalawa po ang titingnan. Why do I say that? Because there's a specific clause in 2018, revised implementing rules and regulations. I'm just going to call them 2018 IRR. There's a specific clause there saying that the casino implementing rules and regulations coexist with the revised implementing rules and regulations. Okay? So dalawa po ang titignan. Then when it comes to judicial issuances, please refer to the rule of procedure in cases of civil forfeiture, asset preservation, and freezing of monetary instruments, property, or proceeds. Now, this particular issuance, again, was of course issued by the Supreme Court in relation to or pursuant to its powers under Article 8, Section 5, Paragraph 5 of the 1987 Constitution to promulgate rules concerning pleading practice and procedure in all courts. It's still effective until now. There haven't been any changes to it. So please look at that rule as well. And it has been used, and it is being used by the Office of the Solicitor General whenever we prosecute cases before the regional trial courts and the Court of Appeals. It's the same procedure being used by the Court of Appeals, subject to changes that were made by the laws. So yung substantive law, binabago rin yung ilang procedural aspects. Only, for example, when it comes to the period, when it comes to the effectivity of a freeze order, it's a matter of substantive law that was eventually carried over into these judicial issuances. So yun, that's the legal framework that we have to look at, that I'm referring to when we talk about AMLA. It's a combination of a lot of laws, and like I said, it's a practice in and of itself. And I'm sure that many of you might not be engaging in the practice of enforcing anti-money laundering laws, or defending clients who have been charged with or are being sued under the Anti-Money Laundering Act. But still, it's good to know that all of these laws exist and that there's a need for us to consolidate them in our minds because they are scattered in different documents. Okay, so now let's talk about the crime of money laundering. Kanina pa natin pinag-uusapan yung framework, but we haven't really discussed what money laundering is. Okay, so in Republic Act number 9160, first thing that I have to tell you that you have to take note of is that there are two general or two broad categories of money laundering. The first one, I call it money laundering proper, and the second one pertains to the crime of a failure to report. But it's also punished as or designated as money laundering. Well, of course, when it comes to criminal procedure, as you well may know, the designation doesn't really count as much when it comes to um, affording the accused of his or her right to be informed of the nature and cause of accusation against him. What matters is that all of the elements, the allegations of fact pertaining to the elements are stated in the information. But just the same, please take note that nominally there are actually two um, crimes or offenses, two broad categories of money laundering crimes under Republic Act number 9160. The first one is what I call the money laundering proper. And these are the elements. First and foremost, because it's money laundering, it has to involve some money or some property. And that monetary instrument or property, monetary instrument class, it refers to this whole category of money, coins, cash, checks, bank deposits. So those are called monetary instrument. They're all lumped into it. And then property pertains to other personal and real property. And what's a problem with these monetary instrument or property? They must represent, involve, or relate to the proceeds of an unlawful activity. Okay? And in Republic Act number 9160, up until its last amended in Republic Act number 10927, there are now 33 crimes listed in the law. Okay? And among them, as I've been mentioning a while ago, are terrorism and terrorism financing, possession or sale of prohibited drugs, and there are also other drug crimes listed there, but I just wanted to emphasize possession or sale. The ones I put here, the examples, they're merely examples, all right? This is not an exhaustive list. To be more exhaustive, please refer to Section 3I of Republic Act number 9160 as amended. So there are now 33 crimes there. 34 if you count the last paragraph pertaining to other crimes of which there's an equivalent crime in foreign countries. Okay. Plunder is also one other predicate crime. That's what we call it. Another unlawful activity under Section 3I of Republic Act number 9160. And please take note of this, that tax evasion is not one of the predicate crimes. Bakit gusto kong emphasize yan? Because there have been efforts to include tax evasion, okay, as one of the predicate crimes. It might be asked in the bar exam, so there might be an example or like a hypothetical question there which involves tax evasion as one of the predicate crimes, but it's not. So pag nag-commit po ng tax evasion ng isang individual, yung pong monetary instrument or property, yung proceeds na nanggagaling doon sa tax evasion na yon, hindi po yun mahahabol as a crime or like for purposes of civil forfeiture under the Anti-Money Laundering Act. Perhaps there are other remedies falling under the NIRC, but definitely not under the AMLA. Okay, so please take note that tax evasion is not one of the predicate crimes, although there have been efforts to include tax evasion as one of the predicate crimes. The next is what we call the scienter requirement. That the offender must know that the monetary instrument or property represents, involves, or relates to the proceeds of any unlawful activity. Okay. This makes the crime of money laundering, in other words, a mala in se crime, because there's a requirement of knowledge, of scienter. Good faith, in other words, is a defense. If there's any difficulty in proving the crime of money laundering, is that almost always it's dependent on indirect evidence based on circumstances. Because like, usually an offender, of course, if not always, would deny that he or she knows that a certain monetary instrument or property represents, involves, or relates to the proceeds of an unlawful activity. And then the act or omission involved would be those found again in Section 4, that a person transacts with the dirty money, converts, transfers, disposes the dirty money, conceals or disguises the dirty money, etc. But one thing that I also want to point out under Section 4 is Clause F of Section 4, performing or failing to perform any act as a result of which the person facilitates the offense of money laundering. This may sound familiar to some of you because this is the basis for the indictment and eventual conviction of Maya Digito, the bank manager of RCBC involved in the Bangladesh money bank heist case. So, yan yung money laundering proper clause na involved doon sa kasong yon. So again, when we talk about money laundering proper, these are the elements, okay? And the acts or omissions involved are the ones enumerated here. And as I mentioned a while ago, there's another kind or category of money laundering also found in Section 4, that which constitutes a failure to report. Okay, it's a crime of omission. It says there that money laundering is also committed by any covered person. Okay, and covered persons are also enumerated in the law. It pertains to banks and financial institutions and designated non-financial sector businesses. Casinos, for example, jewelry dealers are also covered by it. And this crime, the second kind, it is committed by a person, a covered person, who fails to report a covered or suspicious transaction. Okay? And that person also must know that there's such a reportorial requirement on his or her part. And what is a covered transaction? Kanina pinag-usapan natin to under Republic Act number 9160. The original amount was an amount in excess of 4 million pesos, amended in Republic Act number 9194, and it has been that way since 2003. It pertains to a transaction in cash or other equivalent monetary instrument involving a total amount in excess of 500,000 pesos within one banking day. Okay, and then a subsequent amendment was made in 10927, Republic Act number 10927, pertaining to casinos. It says there, for covered persons under the casino law, a single casino cash transaction involving an amount in excess of 5 million pesos or its equivalent in any other currency. Okay, so pakitandaan po yung pangalawang klase po ng covered transaction na yan because it's a recent amendment. To the best of my knowledge, it hasn't been asked in the bar exam since the law was enacted, so maybe it's ripe now for it to be asked. So please remember this or these provisions on the definition of a covered transaction. And if it's a covered transaction, then a covered person like a bank or an insurance company for purposes of the first kind, and a casino and other kinds of covered persons under Republic Act number 10927, they have to report that transaction to the Anti-Money Laundering Council. There's no discretion involved. They have to report it. And failing which, they may be held liable for the crime of money laundering for failure to report. Now, what's a suspicious transaction? And how is it any different from a covered transaction? One thing that makes it different is that it doesn't have any threshold or amount threshold or money threshold. It says in Section 4 is that suspicious transactions are transactions with covered institutions regardless, okay? Regardless of the amount involved. So hindi mahalaga, hindi natin titignan magkano ba ang amount ng suspicious transaction, may minimum ba to? Okay, so at least for that purpose, hindi naghahanap ng minimum ang ating mga bangko for purposes of reporting suspicious transactions. So, ano po ngayon? Paano natin sasabihin ng isang transaction ay suspicious? There should exist at least one of the following circumstances. Okay, the first is that there's no underlying legal or trade obligation, purpose, or economic justification. So, in the cases I've handled before the trial courts or the Court of Appeals pertaining to this particular requirement, ang nangyayari po dyan, there's evidence that a particular transaction is not backed. Say, for example, by a document, by a deed of sale, or by a deed of assignment. And it becomes the duty or the burden of the other of the party who is being subjected to a suspicious transaction report to show that there is an underlying legal trade or obligation. Kung wala, then that gives rise to an inference that the property or the monetary instrument is involved in the crime of money laundering, i.e. that it relates to the proceeds of a predicate offense, whatever that predicate offense may be. Next is if the client is not properly identified, that's fairly self-explanatory. The third one, which is the most commonly used basis for suspicious transactions, and also for purposes of finding probable cause in freeze order and bank inquiry order. Yung pangatlo, that the amount involved is not commensurate with the business or financial capacity of the individual. Kasi magtatanong ka, paano kang nagkaroon ng ganitong halaga kung ang business or financial capacity mo ay much less? If there's a finding to that effect, then that's considered as a suspicious transaction. And please take note that for purposes of covered institutions, banks for example, may tinatawag pong KYC, yung Know Your Customer. So sa KYC documents nakalagay dyan, ano ba yung source of income nung tao, hihinga ng ITR. And dun makikita, paano kang magkakaroon ng deposit of this amount when your ITR or other documents are saying that you have income much less than that. So that can give rise to an inference that, again, the property or monetary instrument that you're trying to transact with is involved in the crime of money laundering. Another thing, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the Act. Paano naman to? Subject of reporting requirements. Let's go back to the definition of a covered transaction. Ang covered transaction magkano? The general rule, if it doesn't involve the covered institutions, covered persons under the casino law, in excess of 500,000 pesos. Okay, within one banking day. Take note of that, within one banking day. So say for example, that a person goes to a bank today and made a deposit of 250,000 pesos. And then the next day makes another deposit of 250,000 pesos. And then the next day makes another deposit of such amount. Every day, hindi matitrigger yung covered transaction repertorial requirement. Bakit? Kasi nakalagay po sa batas, within one banking day, it should be in excess of 500,000 pesos. Because of that, na iwasan or hindi na i-report yung transaction. It's not considered as a covered transaction under Republic Act number 9160. But if there are other circumstances that would give rise to the conclusion that these transactions were structured so that the covered transaction repertorial requirement would be avoided, then the covered institution must also report that transaction or those transactions, as suspicious transactions. Okay? And the others are also fairly self-explanatory, like deviating from the profile of the client, meaning titignan, ano ba yung dating transactions nitong kliyente ng bangko, halimbawa, ano yung mga past transactions niya, bakit ngayon biglang malaki. Kahit na hindi siya mag-trigger ng excess of 500,000 pesos, if it's a deviation from the profile of the client or the past transactions of the client, then that gives rise to the inference that the transaction is a suspicious transaction. Okay. And the next ones are what you call catch-all provisions, specifically the last one, any transaction that is similar or analogous to any of the foregoing. So bakit ba may ganyan? Bakit po may catch-all provision? Because it's hard for Congress to imagine all of these circumstances that could give rise to an inference of suspicious transactions. Criminals would always find a way to launder money, to make dirty money clean. So if there's only an exhaustive list, if there's an exhaustive list in the law, then that binds our executive bodies like the AMLAC and other agencies involved in the implementation and enforcement of anti-money laundering laws to enforce these laws, to prosecute crimes, to detect crimes, to detect money laundering. Kaya po mayroong catch-all provision. Okay, so I was referring to the different characters or entities, agencies involved in the enforcement of anti-money laundering laws. Now, specifically with regard to the criminal prosecution, okay, the prosecution of the crime of money laundering, there are two entities that you have to remember for purposes of the trial. And this is found in Section 5 of the Anti-Money Laundering Act. The first entity that you have to consider or take note of is the Department of Justice. Ano pong papel ng ating DOJ? Ang papel po ng Department of Justice is that they prosecute the crime of money laundering for private individuals and or public officers who do not fall under the jurisdiction of the Sandigan Bayan. So they file the crime or the complaint, the information before the regional trial courts. But if the public officer falls under the jurisdiction of the Sandigan Bayan, then the prosecutorial agency would now be the Office of the Ombudsman, as well as for private individuals acting in conspiracy with those public officers falling under the jurisdiction of the SB. And the information would then be filed before the Sandigan Bayan. Okay, now sir, paano po ang Office of the Solicitor General? Ano pong papel ng tanggapan ng taga-usig panlahat? The Office of the Solicitor General has no involvement in the prosecution of crimes at the trial level. Please take note of that. Even for other crimes, we have no involvement in the prosecution of crimes at the trial level. Hindi po ito nakasaad sa AMLA. Instead, nakasaad po ito sa Administrative Code and in the Charter of the Office of the Solicitor General. And in both documents, it states there that OSG's participation starts when the criminal case is now on appeal before the Court of Appeals and the Supreme Court. So say for example, that an accused was convicted by the Regional Trial Court or by the Sandigan Bayan for money laundering, convicted of money laundering. Okay. And the accused wants to appeal the case. If from the Regional Trial Court, appeal to the Court of Appeals. If from the Sandigan Bayan, appeal to the Supreme Court. Now, the jurisdiction of the Office of the Solicitor General would now start there. And the Office of the Solicitor General would represent the people of the Philippines in the appeal before the Court of Appeals and the Supreme Court. So these are also some of the cases that we handle. Hindi kami yung naglilitigate sa trial level, but when it comes to appeal, that's when we come in, that's when we enter the picture. Okay. One thing that you also have to take note of, I think this is also part of the bar exam syllabus, one of those emphasized, is that a person may be charged with and convicted of both the offense of money laundering and the unlawful activity. In other words, the predicate crime. Ano pong ibig sabihin yan? Ang sinasabi po ng Section 6 ng Republic Act No. 9160 as amended, kapag ang isang tao ay kinasuhan sa ilalim po ng Money Laundering Act, hindi po noon ibig sabihin na hindi na siya pwedeng ma-charge at ma-convict para dun sa predicate offense. Take note, kanina pinag-usapan natin, ano ba ang dalawang uri ng money laundering? Money laundering proper at saka yung failure to report. For the failure to report, it doesn't involve any unlawful activity as an element. It doesn't involve a predicate offense. Okay? But for money laundering proper, kailangan merong predicate offense. Yung isa sa mga unlawful activities, one of the 33 unlawful activities listed in Section 3I of Republic Act No. 9160. Okay. Take note of this because it might be asked, I don't know, perhaps in criminal procedure, it could be asked in commercial law, it could even be asked in political law on the right against double jeopardy. Okay. Hindi po magko-constitute ng violation ng right against double jeopardy if the person is charged with and convicted of both the offense under the AMLA and for the specific predicate offense and unlawful activity. Kasi ang nakasaad sa ating saligang batas, it is the right against double jeopardy pertains to the right to be prosecuted for the same offense for which you have already been convicted, acquitted, or the case was dismissed without your consent. Okay. Dito magkaiba yung offense. The offense or crime of money laundering, nominally different from the unlawful activity, the predicate offense. Minabuti po ng ating Kongreso na ilagay sa ating Republic Act No. 9160 and subsequent amendments na ang isang tao na kinasuhan at nakita na siya ay guilty sa pag-commit ng money laundering, pwede pa rin siyang makasuhan doon sa predicate offense. So say for example, kidnapping, plunder, terrorism, financing of terrorism, drugs, etc. Another thing that you have to remember is that the prosecution of any offense or violation under the law shall proceed independently of any proceeding relating to the unlawful activity. Okay? You have to take note of that. Hiwalay yung proceeding. In other words, it is the conviction of a person for an unlawful activity is not a quote-unquote prejudicial question for purposes of prosecuting the person for money laundering. Bakit ganon? Kasi imaginein po natin, no, kung wala po yung ganyang provision na independently magpo-proceed, an argument could be made that, hey, I should be held liable first for the unlawful activity before I can be held liable for money laundering. Pwedeng sabihin, prejudicial question yun bago ako makasuhan for money laundering. And I'm using prejudicial question in the broad or loose sense of the term. That's why, again, Congress saw it fit to say, okay, that's not the case. The prosecution of any offense under the Money Laundering Act is independent of any proceeding relating to the unlawful activity. Para hindi po masabi nung akusado na teka lang, kailangan ma-convict muna ako for the unlawful activity. Okay, now, the bar exam syllabus specifically mentions the safe harbor provision. It's a specific examinable material. So let's talk about this concept of the safe harbor provision. Let's backtrack a bit. Kanina, sabi natin, ang covered institutions, covered persons, mayroong obligasyon na mag-report ng covered transactions and suspicious transactions. Di po ba? In fact, it's considered money laundering if they fail to report under Section 4 in relation to Section 6 of the AMLA. Ngayon, paano naman kung kunwari na magkamali sila ng reporting? In other words, and this is particularly relevant for suspicious transactions. What if at the end of the day, the suspicious transaction is not actually related to an unlawful activity or does not involve the proceeds of an unlawful activity? Pwede po bang makasuhan ng criminal case yung bank employees or bank officers or other covered person or individual who makes such a report? Because take note, that's a violation of the bank secrecy law. Nilabas niya yung dokumento. Well, because of this so-called safe harbor provision, the answer as a general rule is no. Okay? It's, in other words, there's a safe harbor, there's a protection, a mantle of protection given or extended to employees and officers of banks and other covered institutions whenever they make a covered or suspicious transaction report. Kasi nga naman, kung wala, nakakaawa naman, baka hindi na lang sila mag-report dahil sa takot nila na mabalikan sila. But of course, this reporting or reportorial requirement, it has to be complied with in good faith, or it must be exercised in good faith. And if so done in good faith, then whether or not the report results in criminal prosecution under the Anti-Money Laundering Act or any other law for purposes of the unlawful activity, still there would be no administrative, criminal, or civil proceedings against the person making the report. So that's what you call the safe harbor provision. So again, the effect is that covered institutions, their officers and employees shall not be held liable for violating bank secrecy laws for reporting CTRs and STRs, shortcut for covered transactions and suspicious transactions. Okay, but what's a general rule if it doesn't have any exception? So the exception is a person may be held criminally liable if that person communicates directly or indirectly the fact that a covered or suspicion transaction report was made, or reports the contents thereof, or any information in relation thereto with another person. Okay, so yun po ang exception. Bakit ganon? Kasi nga naman, ang halaga ng covered or suspicious transaction report or ang object nito ay magbigay balita sa Anti-Money Laundering Council, magbigay balita sa ating mga kinaukulan, hindi para i-chismis, hindi para ibalita sa ibang tao na wala namang kinalaman doon sa covered or suspicious transaction. So if a bank officer or employee communicates or shares that information, even just the fact that a report was made, okay, take note of that, even just the fact that a report was made, kahit hindi siya yung gumawa mismo ng report, kahit ka-opisina niya yung gumawa ng report, the fact that a covered or suspicious transaction report was made, that already constitutes a criminal violation, okay, of the bank secrecy laws in relation to AMLA. So again, this is the safe harbor provision. Please take note of that. Protection, mantle of protection. It pertains to the immunity. Okay, that's what you call it. The immunity of persons making covered or suspicious transaction reports in good faith from administrative, criminal, or civil proceedings. All right. Now let's talk about the Anti-Money Laundering Council. The Anti-Money Laundering Council is a financial investigation unit or financial investigating unit, among other functions. So what it does is to investigate, look into transactions, property, assets, monetary instruments that could relate to money laundering. So that's one of the duties of the Anti-Money Laundering Council, and its primary duty, in fact. Now let's look at its composition. The AMLAC is composed of 3 individuals. The first one is the governor of the Bangko Sentral ng Pilipinas as the chairperson. The chairperson of the Insurance Commission as a member, as well as the chairperson of the Securities and Exchange Commission. Okay, bakit po yan yung tatlo na kasapi ng Anti-Money Laundering Council? Because many of the, if not all of the covered institutions, okay, those who are supposed to make reportorial, to comply with reportorial requirements, are regulated by these 3 institutions, by these bodies. Kaya sila yung bumubuo ng Anti-Money Laundering Council. Patandaan po natin, ang AMLAC Secretariat ay hindi po miyembro nung konseho mismo. Instead, the AMLAC Secretariat assists the AMLAC, and the Secretariat is headed by an executive director who is appointed by the AMLAC. And that executive director is a person who, for example, in relation to the OSG, would sign the documents of verification when it pertains to the filing of a request or a petition for civil forfeiture, or a petition for the issuance of a freeze order or bank inquiry order. Because the executive director has gone through the documents prior to the filing of a particular case. So that's a duty among others of the executive director, aside of course from managing the affairs, the day-to-day affairs of the AMLC. And please take note that there's a requirement, okay, there's a requirement in Republic Act number 9160 as amended, that the AMLAC must vote unanimously in order to exercise its powers. Okay? Lahat po sila kailangan bumoto pabor sa isang desisyon na nagpapatupad ng isa sa kanilang mga kapangyarihan. So yan po yung nakalagay sa Anti-Money Laundering Act. Okay. Now this one, the header here is supposed to be just pertaining to the AMLAC, not to the prosecution of money laundering. I'm sorry about that. But let's distinguish between powers that the AMLAC can do without the intervention of other agencies, and those that they can do only with the intervention of other government agencies. Punta muna tayo dun sa powers that they can do with the intervention, okay? Only with the intervention of other government agencies. One thing that we already talked about is the prosecution of the crime of money laundering. Can be done only through the proper prosecutorial agencies, the Department of Justice or the Office of the Ombudsman, as the case may be. So halimbawa, may finding of probable cause ang AMLAC for the commission of the crime of money laundering. Without the DOJ or the ombudsman's support or favorable support with regard to the complaint or of the complaint, then prosecution cannot be had because the AMLAC doesn't have the standing of its own to prosecute a crime. It must go through the Department of Justice or the Office of the Ombudsman, as the case may be. Same thing when it comes to the remedial proceedings. When I say remedial proceedings, I'm referring to petitions for the issuance of a freeze order or a bank inquiry order, or for the institution of a civil forfeiture case. As a general rule, the Anti-Money Laundering Council should ask the OSG to institute the petitions for the issuance of a freeze and bank inquiry order. That's a general rule. Exceptions we will be discussing later. And in all instances, for purposes of forfeiture cases, lahat po yan dadaan sa Office of the Solicitor General. So halimbawa po, kami sa Office of the Solicitor General, kinakausap kami ng AMLAC. Ito, isang kaso, meron kaming nakitang probable cause for that these monetary instruments or property are related to money laundering or involve proceeds of money laundering. And they have to go through the Office of the Solicitor General and we sign the pleadings. And the Anti-Money Laundering Council only signs the verification. Sila yung magbibigay sa amin ng lalamanin nung petition. So in other words, it's like the AMLAC is a client of the Office of the Solicitor General, and they can't file anything before the courts unless it's through the OSG. So those are powers that can be done by the AMLAC, but only with the intervention or participation, perhaps is a better word, of other government agencies. And they have powers that they can exercise without the intervention or participation of other agencies. The first one is to require the submission of CTRs and STRs. Kanina pa natin pinag-uusapan. So even without the participation of the OSG, for example, or other agencies, they can ask, okay, covered institutions to submit those reports. It can also order covered persons to determine the true identity of the owners of a covered or suspicious transaction if the true identity has been concealed or is for some reason confidential. It can also receive and take action on requests from foreign states for assistance. So if there's a mutual assistance treaty between the Philippines and another state, say for example, between the Philippines and another country, say the United States, then the Anti-Money Laundering Council has the power, if not the duty, to receive and take action on that. So why do I say duty? Because as I said a while ago, we have international obligations, or we have bound ourselves to certain international treaties and conventions for the promotion of international cooperation with regard to the prevention, detection, and prosecution of money laundering. So although of course AMLAC has a discretion to take action on a particular request, that discretion should be exercised in such a way that it's compliant with our international obligations. So and of course AMLAC has been doing that, especially with regard to cases coming in from the United States or coming from the United States because of the treaty that we have with the US. Okay, so now let's talk about remedial proceedings. This is an interesting, I would say, practice of law. Some of you might be interested in doing this in the future, the prosecution of civil cases, if not the criminal cases that we already talked about. But the remedial proceedings, think of them as remedies available to the government in order to be able to secure the proceeds of money laundering. Okay. Kanina sabi natin, ano ba ang layunin ng anti-money laundering legislation natin? It's to prevent the commission of money laundering. And if money laundering has indeed been committed, then there must be a remedy, right? And that remedy is to be able to secure those assets, monetary instrument, or property that have a relation to an unlawful activity. And that can be done only if the law is provided for the remedies. And the remedies or remedial proceedings that are available to the AMLAC are the issuance of a bank inquiry order, a freeze order, and an order of civil forfeiture. Okay. Now, the order of civil forfeiture, please take note, is different from forfeiture that can be had if a criminal case has been filed. Dun sa criminal proceedings, of course, forfeiture can also be the ultimate remedy aside from the imposition of a penalty. but a civil forfeiture case can proceed independently. All right, and we're going to discuss the details of that in a while. Let's go to bank inquiry orders first. Let's go to our general framework or general rules when it comes to bank deposits, whether what they call this, foreign deposit accounts or domestic, meaning non foreign currency deposits. The general rule is that these bank deposits are covered by secrecy, by confidentiality, and the laws provide for several exceptions. And one way to pierce that secrecy is through the issuance of a bank inquiry order. All right, so how do we obtain a bank inquiry order? So again, these bank inquiry orders, they can be obtained by the AMLAC through the Office of the Solicitor General. Pakitandaan po yun, dadaan muna sila ang AMLAC po sa OSG. At saan po ito sinasampa? Ang petition po involving or for the issuance of a bank inquiry order ay sinasampa sa ating Court of Appeals. And the Court of Appeals, under the most recent legislation, has to resolve the bank inquiry petition within 24 hours. All right? They have the duty to resolve it within 24 hours. Bakit, sir? Bakit kailangan within 24 hours? What's the urgency? Well, come to think of it, again, money laundering pertains to the crime of cleaning dirty money. And if the agencies, if the courts, if the characters, the parties involved, the government is slow to act when it comes to coming after a particular entity, a particular person who is believed to be committing or is about to commit money laundering, then the proceeds would have been cleaned already. Okay. And although the money can still be recovered by the government, the fact remains that it's going to be more difficult on the part of the government to do so. Okay? Pinahihirapan yung pamahalaan na habulin yung salapi. Because it may well be that the person who will be prosecuted wouldn't have enough assets of his or her own. Nilipat sa iba. So hahabulin pa yung ibang tao. It would be difficult to trace those persons perhaps. So kailangan mabilisan yung pag-akto ng pamahalaan at pati na ng korte. Kaya minabuti ng ating Kongreso na ilagay sa Section 11 ng AMLA na ang Court of Appeals kailangan pong i-resolve yung mga petition within 24 hours. And again, this only just pertains to a bank inquiry order. So even at that stage of a bank inquiry order, meaning authorizing the AMLAC to look into, to inquire into and examine bank deposits, those petitions must be resolved within 24 hours by the Court of Appeals. And take note of this amendment, okay? This amendment. In the laws subsequent to Republic Act number 9194, meaning those that were strengthening the AMLA, nakalagay po na ang bank inquiry orders, they can be issued upon an ex parte application by the AMLAC through the OSG. What do we mean by ex parte? Meaning even without prior notice, all right? Even without prior notice given to the owner of the property or the account holder of a bank deposit, still a bank inquiry order can be requested by the AMLAC. Bakit? Ganito. Noon, yung legal framework po natin under the original AMLA, Republic Act number 9160, the petition should be done only by notifying the other party. Okay, and then the case has reached the Supreme Court to that effect. But then the law was amended. All right, the law was amended. And in at least two cases, in 2016 and in 2017, the case of Subido versus Court of Appeals and Republic versus Bolante, the Supreme Court said that ex parte application is not unconstitutional. Okay? Pinapayagan ang ex parte application. Okay, bakit? Again, why is it that the law authorizes ex parte application? And one of these cases, I think it was a Subido case, was penned by Justice Brion, if not the Bolante case, where the Supreme Court, through Justice Brion, explained that the reason why we're allowing ex parte application is because if you don't follow that rule, then there might come a time that the owner or the account holder would have already disposed of the monetary instruments or dissipated the contents of a bank account, say for example, if he or she is informed that the AMLAC wants to look into his or her deposits, kaya po nilagay sa batas, pinalitan, ginawa na ex parte application without notice to the individual involved. So that is not unconstitutional according to the court. And take note that the quantum of evidence required is probable cause. Probable cause at what? That the deposits, bank deposits represent, involve, or relate to the proceeds of an unlawful activity. Okay? And in order to prove, in order to establish probable cause that certain deposits represent, involve, or relate to the proceeds of an unlawful activity, the AMLAC, based on its 2018 IRR and prior rules, the most recent, as I mentioned, 2018 IRR, through the OSG, will have to rely largely on circumstantial evidence. And in many cases, the courts have allowed this. Because, of course, the AMLAC is not in the bank or is not beside a person committing, while that person is committing an unlawful activity. So necessarily, the court, the court and of course the agencies will have to rely on circumstantial evidence. Ano pong ibig sabihin nun? So say for example, balikan natin, suspicious transactions. Ba't sila nire-report ang suspicious transactions? They are reported because of certain circumstances that give rise to the inference that they relate to an unlawful activity. If an account, for example, was deposited or is used to deposit money to avoid reportorial requirements as a covered transaction, or if the transaction deviates from the profile or the past transactions of the person, then all of these are circumstances that could give rise to the inference that the deposit represents, involves, or relates to the proceeds of an unlawful activity. Okay, so that's what we mean by probable cause. It's a very low threshold, the lowest one, in fact, and you would recall that this is the same standard in order for the prosecution to file a criminal case before courts. It's also the same standard that is used under Article 3, Section 2 of the 1987 Constitution to allow the issuance of a search warrant or a warrant of arrest. So same thing, the court has upheld this requirement of probable cause, just probable cause, for the issuance of a bank inquiry order. And also the same for later for freeze order. Okay, so as a general rule, a prior court order is required. Okay, kailangan pumunta muna sa Court of Appeals ang gobyerno bago silipin ang mga deposito o investment ng isang tao. Exceptions, please take note of these exceptions. If those bank deposits involve kidnapping for ransom, drug violations, hijacking, destructive arson, murder, terrorism, or financing of terrorism. Okay? So ilan po yung predicate offenses na yan? 1, kidnapping for ransom. 2, drug violations. 3, hijacking. 4, arson. 5, murder. 6, terrorism. 7, financing of terrorism. Outside of those 7, okay, outside of those 7 predicate offenses or unlawful activities, then the AMLAC through the OSG must secure a prior court order. But if they fall under these 7, pwede na po kahit walang prior court order, ang AMLAC, pwede nang silipin ang bank deposit. And this is a very limited list. It's an exhaustive list. So please memorize it. Okay. Let's talk about freeze orders. Also filed before the Court of Appeals, must be resolved within 24 hours. Also ex parte, and as explained by the Supreme Court, it is independent of criminal proceedings. So the probable cause requirement is the same as for the issuance of a bank inquiry order, and it is effective for an original period of 20 days, subject to an extension of for a total of 6 months, including the original 20-day period. Okay. So, pag nagsampa ng kaso, nag-issue ng freeze order ang court, that period should only be for 20 days. All right. And then during the 20-day period, what should the Court of Appeals do? The Court of Appeals should conduct a summary hearing. Okay? What's the purpose of that summary hearing? The purpose of that summary hearing is to, first of all, to give notice to the party so that the other party could also be heard. Okay, anong masasabi mo patungkol sa um, pagka-freeze ng assets mo? If the other party is not able to discharge its burden of evidence, okay, I use the term burden of evidence instead of burden of proof. If it's not able to discharge its burden of evidence, as against the evidence of the AMLAC, that there are circumstances showing that the deposits represent, involve, or relate to the proceeds of an unlawful activity, then what happens is that the freeze order can be extended by the Court of Appeals, okay, to a total of 6 months, including the 20-day original period. All right. If the party, on the other hand, was able to discharge its burden of evidence, na okay, the reason why, or in other words, like explain why a particular transaction was done to deviating from the profile, or was able to show some evidence that this particular transaction is in fact a legitimate transaction or obligation, then the Court of Appeals will dissolve the freeze order. Okay? In the middle, there's a possibility also for the Court of Appeals to modify the freeze order. So say, for example, instead of giving the government a total of 6 months, it could be anywhere or any time less than 6 months. Okay. And in non-practice, in the cases I've handled before the Court of Appeals, the Court of Appeals has done or conducted a summary hearing, and that's how it's conducted. So all 3 justices would be conducting the hearing to which a case has been assigned, and the parties would be presenting their evidence as the case may be. So once the private party has presented its evidence, then of course the government also can present its rebuttal evidence. But remember that at that point, the government had already filed a petition, and in the petition attached are documents. That's what we do. We already attach documents to the petition for the issuance of a bank inquiry order or a freeze order to support our finding of probable cause. So nandun na po yung report ng AMLAC. Of course, even the transactions alleged to represent money laundering are part of that evidence. So yun po yung ginagawa doon sa summary hearing. And they often last from like 30 minutes to like maybe an hour. And the Court of Appeals would then issue an order recalling the freeze order or extending it as the case may be. And the party has certain remedies, of course, from the issuance of a freeze order. The first one is to ask the Court of Appeals to lift the freeze order. Injunctions are generally not available except if they're secured from the Supreme Court. Please take note of that. And finally, according to the Supreme Court in Ligot versus Republic, the remedy from a freeze order as well is a petition for review on certiorari. And a Rule 65 petition for certiorari is not available, except, of course, if there's grave abuse of discretion. But the general rule is to file a petition for review on certiorari. Yan po ang nakalagay sa Section 57 ng Rule in Civil Forfeiture Cases. And this was upheld by the court in Ligot versus Republic. So yeah, that's a picture behind a freeze order. That's a procedure behind the issuance of a freeze order. And again, here we're talking about a court-issued freeze order. As a general rule, should be obtained by the AMLAC. Except, again, when the properties or monetary instruments involved are those that relate to terrorism or financing of terrorism. So sa bank inquiry order, kanina na pag-usapan natin mayroong 7 predicate offenses or unlawful activities. Okay? Na kung saan ang AMLAC po pwedeng magtingin or sumilip ng mga bank deposits even without a prior court order. For a freeze order, 2 lang, terrorism at financing of terrorism. So please take note of that. If you're asked to make a distinction in the bar exam, or say for example, you're handling a case involving a freeze order, or like AMLAC conducting its own freezing of monetary instruments or property, please take note of this. Kapangyarihan po ng AMLAC na hindi nangangailangan ng court order, limitado sa terrorism at financing of terrorism for purposes of freezing property or monetary instruments related to an unlawful activity. Okay. Just a quick refresher, kanina napag-usapan din natin yung anti-terror bill. And I was discussing it in the context of a bank inquiry order and a freeze order based on sections 25 and 35 of the anti-terror bill. At ang nakasaad nga po doon, pag dinesignate ng UN Security Council, okay, ng isang institusyon, isang tao o organisasyon ay isang terrorist, individual, organization, or association, then the AMLAC is given the authority to inquire into those bank deposits or to freeze the assets of those individuals or organizations, which makes it different from our current legal framework, which requires the finding of probable cause. Okay? So in other words, even for purposes of the AMLAC itself, freezing the assets or inquiring to the bank deposits, kailangan meron pa ring probable cause. But for purposes of the anti-terror bill, it dispenses with that requirement if passed, if the bill is signed into law, then it dispenses with the probable cause requirement. Ang probable cause requirement kasi, nakita na ng UN Security Council. That's the reason why. Okay. Now, this is what you call like the end, like the most important part of an anti-money laundering proceeding. Tandaan natin, kung hindi naman mahabol yung pera, yung salapi, sayang lang. Right? Sayang lang yung paghahabol, yung pagsasampa ng kaso. So, dapat merong remedyo. That's what you call an order of civil forfeiture. And this order of civil forfeiture, unlike, all right, take note of that, unlike a freeze order and a bank inquiry order, a petition for civil forfeiture is filed before the regional trial courts, which have jurisdiction over the crime, and then over the offense, sorry. And then this civil forfeiture proceeding proceeds independently of the criminal case. Okay? Please take note of that. It proceeds independently of the criminal case. So kahit na wala pang sinasampang criminal case, pwede nang mag-file ng civil forfeiture proceeding. Okay. And another distinction between civil forfeiture on the one hand and bank inquiry or freeze order on the one hand is that the quantum of evidence required in petitions for civil forfeiture is preponderance of evidence. It's a notch higher than probable cause. Doon sa freeze order at sa bank inquiry, ang kailangan lang probable cause. Dito, preponderance of evidence that properties or monetary instruments represent, involve, or relate to the proceeds of an unlawful activity. So for example, what evidence could give rise to the inference that these properties represent, involve, or relate to an unlawful activity? So kanina, napansin niyo, ganyan din kung babasahin yung mga circumstances, they're almost the same as suspicious transactions. And here, kung ang difference niya doon sa suspicious transaction is that the person making the suspicious transaction report is a covered institution. Here, the finding of preponderance of evidence is made by the court. All right. And the procedure is something like this. So it starts with the filing of the petition, and a provisional asset preservation order is issued by the court. And that provisional asset preservation order can be extended to an asset preservation order. Para saan po itong PAPO at APO? Tandaan natin, kanina, sabi natin, ang freeze order, ang buhay niya lang originally 20 days, can be extended to a maximum of 6 months. All right. That period of 6 months, the Congress contemplated should be enough for the Anti-Money Laundering Council to conduct its investigation. Okay. And during that period, the person cannot dispose of his or her assets, could not dissipate his or her bank accounts. Once a petition for civil forfeiture is filed in court, a provisional asset preservation order can be asked by the Office of the Solicitor General. Okay. But for the entire proceedings, kailangan ng mag-request ng OSG ng asset preservation order that will last until the end of the proceedings, that is until judgment is rendered. So in the summary hearing, it's basically the same process as what happens during a freeze order summary hearing conducted by the Court of Appeals. And then pre-trial should be held, trial, and then judgment. All right. And then there's this separate procedure of what we call a claim. What's this claim? Let's say, for example, that a person argues that the assets involved in the procedure, okay, involved in the petition for civil forfeiture, are the proceeds of a legitimate business activity or obligation, and that person was not included in the proceedings before the regional trial court. Anong remedyo niya? That person could file a claim. You call it either a contested or an uncontested claim, meaning if the AMLAC doesn't contest it, then an order can be issued by the court saying, okay, I'm going to separate these proceeds, these property or monetary instruments from the order of civil forfeiture. But if it is contested by the Office of the Solicitor General, then a hearing would be had, subject to an order by the court, whether to exclude those claimed assets or property or monetary instruments from the coverage of the civil forfeiture order. Okay? So, yun po yung proseso. In other words, because it might be possible for a person not to be notified or informed of a petition for civil forfeiture, especially if that person is the recipient of the dirty money and not knowing that that dirty money is involved or relates to an unlawful activity. This claims process was devised by Congress para meron pa rin silang remedy. All right? But please take note that, okay, before this one, but please take note that under Section 10 of the Republic Act number 9160 as amended, while it is true as a general rule that only those property or monetary instruments that relate to, involve, or proceed from the proceeds of an unlawful activity are subject of an order of civil forfeiture, by way of exception, okay, assets of equal value may also be forfeited. What does this mean? So say for example that a certain piece of property was transferred to another person, and let's say for example that the government is no longer able to trace the recipient of that property. What should the government do now? Because the Congress specifically put in here that assets of equal value may also be forfeited, the government could therefore also look for other property or monetary instruments of the person who committed money laundering and claim or go after those assets instead. So say for example that that the person has several other assets, like a parcel of land that was obtained way before the commission of money laundering, then that property, if it is of an asset of equal value with the proceeds that are being sought after by the government, then that parcel of land can also be the subject of forfeiture. Now, why did Congress have to make this exception? Because again, without this exception, then the government would only be authorized to go after those property or monetary instruments that actually involve the proceeds of unlawful activity. If that's the case, then it makes it difficult for the government to go after or to fulfill its mandate, its obligations to prevent and deter the commission of money laundering. Another exception is if there's a payment of the amount of forfeiture. So in other words, what happens is the offender pays an amount equal to the value of the proceeds. So that's another way to go around it. But these apply only under certain instances. Like for example, when the property or monetary instruments that relate to the proceeds can no longer be located despite the exercise of due diligence, or if those property or monetary instruments have been substantially altered or destroyed, etc. So these are the exceptions to the general rule of an order of civil forfeiture covering only those property or monetary instruments proved to be involved in or related to the proceeds of an unlawful activity. Okay, so let's just make a rundown. Our time is almost over. So let's just make a rundown or a summary of the different orders that we discussed. So freeze order is an independent action that is filed before the Court of Appeals. Its period is original 20 days, maximum of 6 months. The remedy is a motion to lift. Its effect is to freeze or to prevent a person from transferring, disposing, dissipating, concealing, moving, or removing particular assets or monetary instrument. That's a purpose of a freeze order. Same purpose of a provisional asset preservation order and an asset preservation order. But an asset preservation order or a PAPO, okay, these two are ancillary remedies to a civil forfeiture petition. Okay, so ibig sabihin po, pag natapos na yung 6-month period, effectivity ng freeze order, ideally the government should be finished already with its investigation and then file a petition for civil forfeiture with a request for a PAPO. Imagine niyo na lang po na yung PAPO para po yung TRO. Okay, it's like a TRO, preventing the person from disposing of the assets, and it's only valid for a period of 20 days, original period of 20 days. And the remedy is to ask for the discharge of the PAPO, in other words, by shifting the burden, by addressing the burden of evidence that those property are not proceeds of unlawful activity, and at the same, or to file a counter bond. Basically also just like a temporary restraining order. And then after the 20-day period, mag-expire na yung PAPO. But the petition for civil forfeiture, the proceedings for civil forfeiture could last well beyond 20 days. So what should be done? The Office of the Solicitor General should ask for an asset preservation order that should last for the entire period of the case or pendency of the case. The remedy again would be to ask for a discharge of the order if that person is able to shift the burden or to address the burden that indeed the proceeds are not related to an unlawful activity, and then to file a counter bond. But just look at it from a practice perspective. If the court makes a finding that the property at that stage is not related to an unlawful activity, then it makes the case difficult, if not almost impossible for the government to proceed with the civil forfeiture case. That's why, at least based on my experience in all the petitions for civil forfeiture that I have filed before, the court grants the PAPO or the APO. Because if they don't, then the government would have nothing to go after. That's the first one. And legally, in terms of evidence, by that time, the court had already made the determination that the proceeds are not involved in, do not relate to the proceeds of an unlawful activity. So, nasabi niya na even at the level of probable cause, I was not satisfied that an APO should be issued. So it makes it difficult for the government, again, if not virtually impossible, to argue na maglalast pa yung kaso to reach the level of preponderance of evidence so that the court would issue an order of civil forfeiture. So again, like in the cases I've handled so far, a PAPO and an APO have been issued by the court. All right. Okay, so that ends my presentation on the anti-money laundering law. I hope that it was a helpful discussion with you, or for you rather. And I'm not sure if you could entertain questions, Vixon.
Attorney Anjo, we'll compile questions and then we'll send it to you. Then
all right,
perhaps
okay,
you can provide your answer to it.
Better.
Them rather, the questions.
Sige, that's better.
Okay. So Go ahead.
So yeah, maraming salamat po sa lahat ng nakinig. Sana po may natutunan tayo mula po sa ating lecture ngayong araw. I'm really happy to be talking about the anti-money laundering law. I think it's one of those laws that we barely study, but it's a really important piece of legislation. With or without the anti-terror bill, whether it's passed or not, signed into law or not, the anti-money laundering legislations that we have are all in compliance with, or to further our compliance with international obligations, and of course to address the reality that money is being spent for unlawful activities like drug trafficking, terrorism, kidnapping for ransom, plunder even, violations committed by public officers and employees. So it's an important piece of legislation, and I hope that you found this discussion fruitful if you're taking the bar exam. Or if not, then for purposes of practice, maybe we'll see each other in court. So again, thank you so much. And to Legal Edge as well, thank you so much for organizing this.
Thank you, Attorney Anjo, for that very informative lecture. As expected, you were able to simplify it and provide the key points for the AMLA. So to everyone, on behalf of Legal Edge Bar Review Center, I am again Attorney Vixon A. Mabanglo. Thank you for attending today's lecture, and see you soon, or see you all in especially our reviewees in our review program this year. So thank you, Attorney Anjo, for that very informative lecture.
Thank
So
you.
to everyone, stay safe and God bless.